At a hearing in front of a Georgia workers' compensation judge, you may be able to present evidence that the insurance company did not meet the legal requirements to get the presumption of a positive drug test. The insurance company often relies on this presumption to prove their case. If the drug testing didn't meet the standards and the insurance company does not get this presumption, it's going to be much harder for them to prove that your injury was caused by willful misconduct. Now, even if the drug testing was done properly and the insurance company gets the presumption, that is not necessarily the end of the case. You may be able to present evidence still that your injury was not caused by willful misconduct. Sometimes you can present other evidence that shows that even though you tested positive, that you were not intoxicated or under the influence of drugs at the time of your injury. Some positive drug tests may show up for a while after the drug no longer is having an effect on you. So there are times where other evidence can be presented to demonstrate this, and you can potentially overcome the legal presumption that the insurance company gets. A third approach can be to show that even if you were under the influence of drugs or alcohol at the time of your injury, that you being under the influence of those had nothing to do with your injury. A classic example of this might be if you were riding in a car as a passenger and on the job, driven by another co-employee, and another car just rear-ended you. Now, you being under the influence of drugs in this scenario may have nothing to do with the fact you were injured, because there probably was nothing you could do to avoid that situation, even if you weren't under the influence of drugs or alcohol at that time.